Good morning. I would call the Cannabis Compliance Board meeting for January 25th, 2022 to order. If we can have our roll call, first order of business, show form.
Great, thank you. Member Jerry Merritt?
Here.
Member Rihanna Durrett?
Here.
Member Young?
Here.
Member Nylander?
Here.
And Chair Douglas.
Here.
Great. Deputy Bala, can you confirm that we have complied with the open meeting law requirements?
We have, Director Klimas.
Back
All
to you,
right.
Chair.
Before we take our first item, which is public comment, I'll make an announcement that item number 10 on our agenda this morning, consideration of proposed amendments and or additions to Nevada cannabis compliance regulations, A, B, and C are being pulled from today's agenda. So having said that, we can move to our comments.
We'll get started in Carson City. Is there anyone in Carson City wishing to provide public comment? If you do, please remember to state your name for the record.
It appears no one is here for public comment.
Okay, great. We'll go down here to Las Vegas. Is there anyone in Las Vegas wishing to provide public comment at this time? Please.
Hello. Okay, perfect. Hello, I'm Elijah Gutman. Be commenting on 182 and 183, a couple other regulations. 250,000 liquid capital requirement. The average income of a Black person in Nevada is $24,000. The average income of a white person is $188,000. Let that sink in. It's clear that you don't want non-white people in this industry. This is liberal racism. Our communities have had to rely on cannabis due to lack of health care historically, and now we're being shut out of it. Why keep up the charade? Why go through the process of creating equity licenses when all the regulation prevents any kind of investment except by rich white women? Then you want to outsource minority verification. What do I have to provide a skin graft of my skin for verification? To add on top of that, the required skin graft for verification for minorities, or the verification for minorities is going to be outsourced to a women's rights organization that is made up of rich white women. I wonder if I'll be Black enough according to their standards. Why are family members of people affected by drug laws allowed to apply? This is going to dilute the possibility of people affected by laws to obtain licenses. At least require the person actually affected by drug laws to sign off on a family member opening up something under their minority status. I should have expected nothing more from Nevada after how we handle dispensary licenses. This time around, at least let us know we don't matter. Tell us to our faces you care only about money. We could change the regulation to include all assets a person has, including home, cars, stock, etc. This will make the playing field for lounge licenses more fair for communities in the future. Please reconsider making people prove they're Black enough, or at least move verification to an organization made up of Black people. 300 feet from a community facility, 1,500 feet from a gaming establishment. This regulation is ridiculous. It would make it virtually impossible to invest in minority communities anywhere. Low-income communities are infested with gaming establishments in every street corner. 7-Eleven, gaming establishment. Smith's, gaming establishment. I can go on and on. You want to know what's on almost every street corner in low-income communities? Churches, daycare facilities, and community centers. This leaves no commercial space for lounges, and these regulations leave no hope for our communities. Apparently, the gambling lobby gets priority over our communities, with minorities left to languish like usual. Can minorities ever win? I already know the answer. Absolutely not, as long as white people dominate this industry. Please scrap these regulations. Minorities deserve a fighting chance to succeed. I'm sick of seeing minorities be left to wither away in the dirt. Thank you.
Is there anyone else in Las Vegas wishing to provide public comment at this time? Okay, great. Chair, back to you.
We will move our agenda forward. We have item number 2, meeting minutes. We have A, consideration of approval of December 14th, 2021 Cannabis Compliance Board meeting minutes. And we have item B, consideration approval of December 14th, 2021 Cannabis Board meeting board workshop minutes. we can take jointly or we can take independently if we have any additions or corrections. If it will be considered in the motion to be made for approval, acting on these two items.
Mr. Chairman, I had no changes or corrections to the minutes, and if you're prepared, I'll make a motion on those.
We have a motion for approval. Do we have a second motion?
I second.
All in favor, say aye.
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 And I'm abstaining. I was not at the meeting, even though I've reviewed the minutes. Motion carries. Minutes approved. That moves us to our consent agenda item complaints. We have 2 items. Our presentation.
Thank you, Chair. Item 3 on the agenda concerns 2 complaints for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I'll be requesting board approval to proceed with each of these 2 disciplinary actions. Approved, I'll then authorize service of the complaints. Once the board approves proceeding with disciplinary action, service will proceed within a reasonable time. I anticipate, if approved, the complaints will be filed and served within 1 to 3 weeks. Once they are out for service, they will be posted online. So I'll present the violations alleged and request the board vote to authorize proceeding with disciplinary action. As to respondent A, the complaint will allege violations of NRS 678B and or NCCR 4 and NCCR 7. As to respondent B, the complaint will also allege violations of the same NRS 678B and NCCR 4 or 7. Back to you, Chair.
All right, if we could, proposed violations.
Of the violations, both of the respondents are alleged to have violated NRS 678B and NCCR 4 and 7.
Okay, with that having been said, since we have not seen those pursuant to the regulations, we can have a motion approval so that the director can have those served. So,
Mr. Chairman, this is Member Nylander. I would move that for approval of agenda items 3A, 1 and 2 as posted on the agenda.
any discussion? Well, do we have a second?
This is Member
A
Young. I'll
second.
second that.
Moved and second. Any discussion? All in favor, please say aye.
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 Motion carries unanimously. That puts us to item number 4, consideration of proposed settlement agreement to resolve disciplinary action. We have item A, Cannabis Compliance Board versus Nevada Organic Remedies. We can have report.
Thank you, Chair. Good morning, Chair, members of the board. L. Christopher Rath, Senior Deputy Attorney General. We have one settlement agreement up for approval at this meeting. As usual, I'll provide you with a summary and the Attorney General's recommendation for approval. You may then ask me any questions you wish. The respondent is also present here today to answer any of your questions. This case is CCB versus Nevada Organic Remedies, CCB case number 2021-62. This case does not involve a complaint. Rather, the parties reached an agreement to resolve the regulatory violation that the licensee self-reported to the CCB. Respondent agreed to waive the filing and service of a formal complaint as noted in the settlement agreement. The matter involves an adult use sale that exceeded the single sale transaction limit. On May 10, 2021, Nevada Organic Remedies reported to CCB via an incident report that one of its employees had completed this improper sale on May 7, 2021. The licensee further reported within the incident report that it had undertaken its own internal investigation of the incident and determined that its sales system's transaction limit safeguard had been placed in the off position and the employee had overly relied on the safeguard to provide any warning of a sale in excess of transaction limits. CCB staff reviewed these facts After review of the licensee's self-report, CCB staff then involved the Attorney General's office to negotiate with respondent via counsel to see whether the violations could be resolved with a settlement agreement without the need to file a formal complaint. We did reach a mutually agreeable settlement agreement subject to CCB approval. As indicated in the settlement agreement, after waiving its rights to the filing and service of a disciplinary complaint, respondent admitted to one Category 3 violation for exceeding maximum serving requirements for a cannabis product and agreed to pay a $62,500 civil penalty within 3 days of approval of the agreement. Paragraph 19 of the settlement agreement summarizes the plan of correction, which was contained in the self-report. The CCB staff has approved this. In summary, the sale systems transaction limit safeguard was, of course, turned back to the on position. The licensee further trained its employees to refrain from relying heavily on electronic safeguards and emphasized the importance of staying within transaction limits for single sales. The managers responsible for controlling the electronic safeguards were also counseled to ensure they verified the transactional safeguard limits do remain in place when making system adjustments. CCB staff agrees that this admitted violation, civil penalty, and the corrective action taken appropriately addresses their areas of concern, and that the licensee has been fully advised about and understands the gravity of the mistake. Accordingly, the Attorney General recommends the CCB approve this settlement agreement. I'm available for any questions, as is counsel for the respondent, Amanda Connor.
Good morning.
Good morning, Chairman, members of the board. Thank you to Deputy Attorney General Rath for covering this proposed settlement agreement. What we would like to indicate that my client did self-report this incident and took corrective action on their own before any action was taken by the Cannabis Compliance Board. We appreciate that the board takes that into consideration when considering this settlement agreement. And as Deputy Rath pointed out, as outlined in paragraph 19 of the settlement agreement, my client took several corrective actions to prevent such a thing from occurring in the future.
Questions by the board?
I have a question. The single sale transaction limit, that just means over the 1 ounce limit? Okay. I have a question for staff. Do we, on disciplinary actions, do we have a way of keeping track of previous disciplinary actions? Which has nothing to do with this. I was just wondering
We do.
in general.
We do.
Okay. So maybe could those be included in the future? A record of previous disciplinary actions, if there are any.
Sure, we can do that.
Yeah, we can certainly insert some language into the settlement agreement saying this is a second violation or this is a third violation.
Not that that's the case here.
In general, yes. I mean, we can do that.
And then I do have one thought about the settlement agreement, if that's okay, Chair. Do you want just questions or do you want me to, any comment? I think the amount's really, really high. So I would be in favor of a lower amount since it was self-reported.
And member Merritt, I can explain that a little bit, how we arrived at
Okay.
that amount, if you'd like. So Nevada Organic Remedies did have a prior Category 2 for a transfer of interest, and they were downstream on that transfer of interest, but they did have a Category 2. So technically, this could have been pled. It's a second Category 2 with a $75,000 fine. And what we did, because of the self-report, is we lowered it to a Category 3, and we came off that $75,000. And we took, obviously, their self-report into consideration in arriving at that number, negotiating this case. So that hopefully will provide you with some better background as to how we arrived at that amount.
Thanks.
If I may, Member Durrett and Chairman, I do think that that is an important factor to consider. I appreciate what Deputy Attorney General Rath said in this particular instance, but I do think it's important for the board to remember that, you know, such steep penalties on self-reports is going to discourage people in the industry from self-reporting.
Other questions or points to be made by any board member? If we have nothing else for discussion, if we can have a motion at this point.
I will throw it out there, but I'm perfectly happy to I'm perfectly open to other amounts. I would move to change it to 45,000. I would move to reduce the fine to 45,000 and approve the settlement agreement between the CCB and Nevada Organic Remedies under agenda item 4A.
We have a motion on the floor. Do we have a second for this motion?
Member Merritt, second.
It's been moved second, further discussion. All in favor of the motion for a revised settlement in this matter, please say aye.
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 Aye. Motion carries unanimously. Thank you.
Thank you very much. And thank you, Deputy Attorney General Rath.
Thank you, Chair. We will get you a revised settlement agreement with the new amount in there for you to execute.
Thank you. That brings us to item number 5, request for transfer of interest. We have 2 items. If we have our information, please.
Thank you, Chair. Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I'm David Staley, Chief of the Investigations Division for the CCP. I'm here to present agenda item number 5, which consists of 2 transfer of interest or TOI applications. Item number A is a TOI application, Healthcare Options for Patient Enterprises LLC, HOPE. TOI numbers 17021A, 17021B, 17021C, 17021D, and 21026. Request approval for internal transfers to provide for new minority investors to provide new capital and for Thomas Carson to become a 10.2% shareholder. Staff identified areas of concern with this application regarding a TOI without prior CCB approval and late filed tax returns. Additionally, there is currently a disciplinary complaint proceeding against Hope, which was filed last month and involves issues with tax returns, monthly reports, and aging cards. This disciplinary process is proceeding and discussions have been initiated on a potential resolution of this matter. It may be appropriate for the board to approve the requested TOI and direct the Attorney General's office and CCB staff to include these areas of concern in current discussions regarding the existing complaint. I am available for any questions, and my understanding is that Dr. Howard Rubin and Brianna Martinez are available to address any questions you may have as well. With that, Chair Douglas, I'll return this item to you.
We have the licensee and or representatives present this morning.
Good morning, members of the board, staff, and Chief Investigator Staley. Thank you very much for providing that report. I have Dr. Howard Rubin. He's Hope CEO and managing member with me. I just want to thank Investigator Justice and Chief Investigator Staley for working with us on these transfers. As always, they are a pleasure to work with, and staff in general. Given Chief Investigator Staley's recommendation, we would agree with that if we could please have these transfers approved and negotiate any type of settlement with the disciplinary action we're currently settling.
Thank you. Questions, discussion by the board?
Mr. Chairman, this is Member Nylander. I have a disclosure. Ms. Martinez is a member of the Kemfer Kroll Law Firm, and I am of counsel with the firm. I have no pecuniary interest in the firm or this matter. I was unaware of this matter till I read it today. I'm firewalled off from any cannabis matters. I work exclusively in the gaming industry, so they're not allowed to have any involvement in marijuana, so therefore I am not either. So I don't believe I have a conflict at all, and I would participate in this matter.
Thank you. Again, back to board members, concerns, questions. In the interim, while the board are reviewing their packets, as I reviewed this matter, I do have a concern as to the tax payment. This seems to be a recurring theme. I've heard and noted for it in terms of getting new financial people and this, that, and the other, but it seems to be a pattern. The taxes got cleared up, and all of a sudden, as soon as this year's taxes got paid, license was renewed, we have another period, taxes being standing. That's just flat not acceptable. That has to change. You can pay your vendors, you can pay everything else. That has to be taken care of. If any other board member has a comment, if they don't, I have a motion to approve the TOIs as requested and refer back to our attorney generals to review the outstanding matters for possible.
I second. I don't have questions. I second.
We have a motion, we have a second. We have any additional discussion? All in favor of the motion to approve the TOIs, refer back to the Attorney General's office for investigation recommendations. Please say
Aye.
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 Opposed?
Aye.
Any abstentions? Matter carries unanimously.
Thank you very much.
Moves us to item number B.
Chair Douglas,
Thank you.
before we start on item B, I have a disclosure. And that I have with two individuals involved in this transfer, I have a doctor-patient relationship. Until we received this documents, I had no idea that they were even involved in the cannabis industry. And I do not believe it will affect my ability to be objective regarding the transfer of interest.
Thank you, Member Young. With that, if we can have presentation.
Thank you, Mr. Chairman, members of the board. Item B is the TOI application for the Cannabative or Cannabative. TOI number 19036 was filed by Cannabis requesting approval for Cannabative to repurchase the shares of a deceased member, an internal reorganization of membership interests, and the addition of 8 new minority investors. In addition, Cannabative has requested a waiver of 5.10 pursuant to NCCR 5.5 of the requirements of NCCR 5.110 regarding agent cards. Cannabative has adequately addressed the items required in NCCR 5.112 or required in NCCR 5.125 to allow them to approve such waiver. Staff suggests that if approved, the board limit Cannabative's 5.125 expire on such agenda date as Cannabative's next TOI application is heard. No areas of concern were identified with this application. I am available for any questions, and my understanding is that Zara, I would murder the last name, so I won't even try, is available in Carson City, and Ross Klein available by Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. If we can have the licensee representative. We can bring them on, please.
Hello, my name is Zara Ihaz, and I'm here representing Cannabis Group and the Director of Finance.
If you could speak up, please.
Yep, no problem. My name is Zara Ihaz, and I'm here representing Cannabis Group. I'm the Director of Finance.
If you would like to say something on your behalf as to approvals.
I have nothing to add. I've been working with Jeff Justice on the transfer of interest, and I'm just very grateful for his help and that we've got it finish line. I'm here to answer any questions if there's anything from the board.
Thank you. Board members, anything that you wish to ask, or are you ready to go forward with this? Hearing no questions this time, if we can have a motion for approval of the transfer of interest, that's this matter.
Rihanna, direct for the record, I move to approve item 5B on today's agenda, the transfer of interest requested by the Cannabis Group.
We have a motion for approval,
Member Merritt, I second.
and we have a second. Any additional discussion? Hearing none, all in favor of approval of transfer of interest as to item.
Aye.
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 Aye. Matter passes unanimously. That moves us down to item number 6, request for consideration of approval of management services agreements, and we have 2 items on. We can have our presentation, please.
Chair Douglas, members of the board, for the record, I am David Staley, Chief of the Investigations Division. I'm here to present agenda item number 6, which consists of 2 management services agreements. These management service agreements are related, that the entity providing the service is the same, but because it involves 2 different licensees, we've broken these up into both item A and B. Item A is a management services agreement or management agreement between Tahoe Hydroponics Company LLC Tahoe and CSAC Acquisition and B CSAC, a subsidiary of Air Wellness Inc. or AIR. The management agreement provides for CSAC to provide Tahoe with business, organizational, strategic, management, advisory services, as well as cultivation and distribution, logistics, and operations guidance, while acknowledging that Tahoe maintains ultimate legal responsibility and control of the operations. The management agreement has been put in place pending the completion of staff's review of a transfer of interest application in which AIR has applied to acquire Tahoe. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship between CSAC, AIR, and Tahoe rather than the approval of the agreements themselves. I am available for any questions, and my understanding is that Amanda Connor, Mark Bruno, Jonathan Sandelman, Alicia Ashcraft, Jennifer Drake by Zoom are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. And good morning to the
Hi, good
representation.
morning, Chair Douglas, members of the board, Alicia Ashcraft, the law firm of Armstrong Teasdale on behalf of the applicant management company CSAC Acquisition Nevada or NV Corp, which is a subsidiary of parent company Air Wellness. Available by way of Zoom is Chief Operating Officer of Air Wellness, Jennifer Drake. We're happy to answer any questions the board may have, and also Amanda Connor is here on behalf of the licensee.
Good morning, Chairman, members of the board. Amanda Connor with the law firm Connor & Connor here on behalf of the licensee Tahoe Hydroponics Company. And again, we are happy to answer any questions you may have.
Members of the board, questions, references, relationship?
I have a question. So basically, it's a management agreement that's going to be in place because the transfer is pending. Okay, that's all.
That's correct. It's interim management agreement pending the TOI.
Other board members? If we have no other item, anything to discuss, if we can have a motion for approval as recommended by the investigators of the management services agreement, particularly relationship.
I move to approve the relationship between between Tahoe Hydroponics Company LLC and CSAC Acquisition Nevada Corp. As enumerated under agenda item 6A.
Thank you. Do we have a second?
Member Merritt, I second.
We have a motion, we have a second. Any additional discussion? All in favor, please say aye.
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 Matter carries unanimously. Thank you very much.
Thank you.
Moves to the item, NV Green Inc. and CSAC. acquisition.
Chair Douglas, members of the board. Item B is a management services agreement between Nevada Green Inc. or Nevada Green and CSAC, a subsidiary of Air. The management agreement provides for CSAC to provide Nevada Green business, organizational, strategic, management, and advisory services, as well as cultivation and production logistics and operations guidance, while acknowledging that Nevada Green maintains ultimate legal responsibility and control the operations. The management agreement is put in place pending the completion of staff's review of a transfer of interest application in which Air has applied to acquire Nevada Green. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship CSAC, Air, and Nevada Green, rather than approval of the agreements themselves. I am available for any questions, and my understanding is that Amanda Connor, Alicia Ashcraft, and Jennifer Drake are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item.
And again, good morning.
Good morning again. Chair Douglas, members of the board, Alicia Ashcraft on behalf of the manager applicant CSAC Acquisition NV Corp. Happy to answer any questions on this one as well.
Good morning, Amanda Connor on behalf of NV Green Inc., the licensee. We kindly request approval of the relationship, and I'm happy to answer any questions.
And once again, turn to the members of the board for questions. Concern, or any discussion. Seeing no questions, so with that, if we can have a motion to accept this management services relationship.
I move to approve agenda item 6B, the management agreement between Nevada Green Inc. and CSAC Acquisition Nevada Corp. With the board approving the relationship and not the contents of the agreement.
Second.
We have a motion, second. Any discussion? Hearing none, all in favor, please say aye.
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 Matter carries unanimously. Before we turn to our next item,
Thanks so much.
Thank you.
just note for the record that Cannabis Compliance is looking at our present transfer of interest process and trying to streamline it and improve it for the future, so that we can get everything processed in a faster. With that, we would go to item number 7, request for consideration of approval of placement of receipt. First item up this morning is Inc.
Thank you, Chair Douglas. Again, Christopher Rath, Senior Deputy Attorney General. We've got 3 requests for approval of placement of receiver. I will be doing the presentation on each of them in turn. The first item under agenda item 7A concerns Green Cross of America, license numbers C035 and RC035. Mr. Derek Connor is present as counsel, and Mr. Kevin Singer is present as the cannabis receiver applicant. As the board will recall, this matter first came before the board at the October meeting, where Mr. Hardy sought approval for placement as a cannabis receiver over Green Cross, and you heard from both Mr. Hardy and counsel for the creditor at issue Red Dot. The CCB also heard several objections from some owners and the counsel for the majority owner, and then moved this matter to the December agenda. At the December meeting, counsel for Green Cross and counsel for Red Dot appeared, as did Mr. Hardy. Mr. Hardy's application was withdrawn, and the board approved that, and the parties indicated that they had agreed on Mr. Kevin Singer, and we're going to go through the process with the court to get the court to appoint him. In the interim, the parties stipulated to the court appointing Mr. Singer on January 18. The court signed this order contingent on CCB approval. As additional background, Green Cross, as you're aware, remains on summary suspension, is not currently operating. There is a separate complaint for disciplinary action that was filed for the violations found during the inspection that led to the summary suspension. That disciplinary process is still pending. And also, as with prior receiverships, the CCB staff recommends that the receiver provide the executive director with monthly reports on his activities on the 15th day of each month. And we would recommend that your motion include, if you approve this, that the motion include a requirement to have those reports submitted on the 15th day of each month. I'll now turn it over to Mr. Derek Connor and the proposed cannabis receiver, Mr. Kevin Singer, to make any presentations they may wish to make and answer any questions the board may have. The board can then vote on Mr. Singer's application to be placed as a cannabis receiver. There may be other interested parties also present and may request to be heard on this item. And then after the meeting, we'll prepare an order outlining the fact and confirming whatever decision the board makes in writing. So I'll turn it over to Mr. Connor.
Good morning, Honorable Chair Douglas, members of the board and staff. Thank you, Mr. Rath. That's an excellent summary. I think he pretty much covered everything leading up to where we are now. I'd like to introduce Mr. Kevin Singer, the proposed receiver for this action. We're prepared to answer any questions the board may have, either for Mr. Singer or for myself on behalf of Green Cross.
Understanding that this matter has back and forth, the parties have pretty much agreed to Mr. Singh presenting them as the receiver. Is that correct?
That's correct, Your Honor. There were two underlying cases pending in 8th Judicial, and the parties stipulated to agree to dismiss the case that was pending before Judge Weiss in Department 30, and then they stipulated to agree to the appointment of Mr. Singer in the case that was pending before Judge Denton in Department 13.
Mr. Singer, you have a very extensive background. I guess the two questions I have for you is that familiarity with Nevada cannabis, in other jurisdictions as their cannabis regulations, and because you are a kind of a multi-jurisdiction receiver, how are you going to handle overseeing the operation?
Thank you, Board Member Douglas, for asking that question. Hopefully you've seen by my resume, I've been doing this for 21 years, and I've now served in over 440 court appointments as a court-appointed receiver. I've also run and operated over 12 cannabis businesses in all different aspects of operations. I've read the Nevada Revised Statutes 56, Section 56. I've read the regulations of the Nevada Cannabis Compliance Board. So I'm definitely getting up to speed on all the rules and regulations. Obviously, Mr. Connor is a wealth of knowledge, and I'll be looking to him every step of the way and working with him as well to make sure that everything we do is in compliance with Nevada statutes, laws, and regulations. That was question one. Yeah.
Thank you. Other members of the board?
I have a question, but first you're going to have to pronounce it Nevada.
Sorry about that.
And second, so the previous receiver, there was kind of an indication once he got approved, he was going to make an assessment of whether the finances and assets would make it something that they could handle. So what is that? Which I thought, well, don't you need to do that analysis beforehand? So when does that analysis come in, and kind of what was your general analysis of that?
Correct. If we can move forward through this process and I get approval and license to run and operate this facility, that'll be the first thing that we do, go out, look at it. Most receivership cases, we have a beginning and a middle and an end. I mean, what we're looking to do ultimately in the long term is to transfer this business to somebody who can be approved by this board, who can run and operate this business And obviously, there's extensive fines and penalties by this board. We're very aware of that, and we're going to work to get that paid back.
So that analysis doesn't occur until after you're appointed?
Correct. It wouldn't happen pre-appointment. We already do as part of our normal operating procedure. We do monthly reports, and they do go out by the 15th. So that's nothing new for us. But after we're appointed and I'm approved by this board, hopefully, we would present a report looking at all aspects of the business and make recommendations to the parties, the court, on how to proceed with this business.
So what would happen if you were appointed and you looked at it and found, okay, there's only a big sinking hole. There's no way anybody can, the finances would never be there to make this worth even being a receiver on it. Like even your fees wouldn't be paid. So what happens in that case?
Well,
or does that not happen?
I don't foresee that happening in this situation. I think there's great value in the real estate, in the business that's already there, and potentially if the licenses could be transferred to a responsible party, I see that there's value in this case. And I've consulted with Mr. Connor, who's an expert in this, and he feels the same way, or we wouldn't be standing here right now.
Okay, so last thing is you do some kind of, you look at it and say like, okay, they don't owe 20 million on this license that's worth $1 million or something. There is some kind of preliminary assessment.
Yes, there is some type of preliminary investment. We may not get all creditors paid back, but our goal is to get as many creditors paid back as possible through the sale or transition of the license.
There's a preliminary assessment of the finance.
Yes.
Okay, cool. That's it.
No problem.
Thank you. Thanks, Chair.
And if it helps, Member Durrett, I've given Mr. Singer a general discussion of the status of the business. Now that, once he's approved as a receiver, he'll hold the attorney-client privilege. He gets to see my whole file and everything that I've got on the business.
Thanks.
Other board members have questions? Any concerns? If that is the case, then we're past your motion.
We may want to see if there's anybody else that wants to be heard on this. I don't know if there is or not.
With that having been said, our legal counsel, if we can have your name, please.
Good morning. This is Brian Nadafi from Avalon Legal Group on behalf of Stephen Restefo and Charmin Thomas. They are both owners of Green Cross of America. We have no objection. It appears that the receiver has done the proper due diligence at this point in time. And I've also had many conversations with Mr. Connor. So as far as two of the owners of Green Cross of America, there are no objections. That's it.
Thank you. Any board members? That having been said, seem to be in proper order for a motion.
I move to approve the placement of receiver in Mr. Singer in agenda item 7A, the matter involving Green Cross of America, Inc.
We have a second.
Member Merritt, I second.
We have a motion. We have a second, and I would note for the record that is receiver making application, receiving proper approval from the Cannabis Board for his application, receiver. With that, all in favor, please say
Aye.
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 opposed. Matter passes. You, Mr. Singer.
Thank you, Chair Douglas. Thank you, members of the board, Director Clemis, and especially to Mr. Rath. I appreciate all your help on this. You and Ashley and Emily did an excellent job.
Thank you.
Thank you.
That moves us to item B.
Thank you very much.
CSNLV.
Thank you, Chair. Item 7B concerns CSNLV license numbers C180, RC180, P113, and RP113. Ms. Kimberly Rushton is present as counsel, and Mr. Dotan Melik is present as the cannabis receiver applicant. And I believe Ms. Rushton's clients are also appearing via video. By way of background on this one, on December 1, 2021, Mr. Charles Indig, sole owner of CSL and NLV, passed away. Shortly before his death, Mr. Indig was able to submit a couple transfer of interest requests or TOIs, seeking transfer of 50% of his interest in CSNLV to his daughter, Shayna Indig, and the other 50% to his longtime partner, Ms. Barbara Jean Rubin. These TOIs were pending at the time of Mr. Indig's death. They were sent in very shortly before his death. So CCB staff did not yet have the opportunity to investigate the applicant's suitability. As a result, CSNLV will need a receiver in place while the CCB staff investigates the TOIs and brings them before the board for approval. Without a receiver, CSNLV would be operating without an owner possessing an agent card. Since Mr. Indig's death, Ms. Rubin has been appointed as the executrix over his estate. Ms. Rubin, as executrix, is requesting board approval for the application of Mr. Dotan Melik for placement as a cannabis receiver over the business. Additionally, on December 13, 2021, CCB staff performed a full audit inspection of this licensee and found no violations or deficiencies. It is my understanding that council will also be seeking court appointment of Mr. Melik as a receiver should the board approve his placement. Again, we would also recommend the order include monthly reports by the receiver on the 15th day of each month starting in February. I'll now turn this over to Ms. Rushton and the proposed cannabis receiver, Mr. Melik, to make any presentation they wish and to answer any of the board's questions, after which the board can take a vote on this matter.
Good morning.
Good morning, Chair Douglas, members of the board, Executive Director Klimas. For the record, I'm Kimberly Maxton Rushton with the law firm Cooper Levinson, appearing on behalf of CSNLV LLC, otherwise known as Oro Verde. Joining me today via Zoom are Ms. Shayna Indig, the daughter of Mr. Indig, and Ms. Barbara Rubin, the longtime partner and executrix of Mr. Charles J. Indig's estate. The matter before you is a request for appointment of receivership. If I may, Chairman Douglas, I'd like to just put a couple of facts on the record in addition to that proposed by Mr. Rath or stated by Mr. Rath. As noted, the applications for transfer of interest were filed simultaneous to Mr. Indig's death. Ms. Rubin had actually filed prior to that in October of 2008, or excuse me, 2020 and everything. However, that application was never processed. Ms. Rubin has been appointed as the executrix of this matter. The domicile of the estate is in New Jersey. This is a very small cultivation operation. It's approximately 4,700 square feet and only 25% of it is operating because it's currently under construction. For those reasons, we'd ask for consideration relative to the receiver, if you are inclined to go that route, that you make the terms very narrow. We anticipate this matter being before you for consideration and approval of the transfers of interest in February. So we're talking about less than 30 days why we would have a receiver. So by the time we get through the court process, although we are seeking to proceed through the business court and a demonstration to expedite this, it could take a couple of weeks. And so we're kind of buttressed up with the time in which you will be considering the TOIs. We did submit on December the 13th, the request for alternative consideration in lieu of the receivership, but we're instructed to proceed with this. And so that's the reason we're here. We have absolute confidence in the receiver, his background and familiarity with cannabis. But again, we ask you to consider the fact that Ms. Rubin is an applicant before you. Therefore, she is subject to your jurisdiction. It's her license to lose in the event that you do not feel that she's suitable to go forward. And so an alternative proposal would be to grant her a temporary agent card as an owner and allow her to continue in the process that she is as the executrix until the final approval in February or at the latest March. But again, we respect the fact that this is a new process. We were present during the October agenda in which you approved the receiver, and we have acted in accordance with that. And also would like to thank Director Klimas for his compassion relative to this matter when we first started, and also working with us in conjunction with this as we proceeded through the process. And the same with Mr. Rath. Thank you very much. With that, I'm happy to answer any questions.
Thank you. If we can have any comments by our proposed receiver.
Good morning, Chair Douglas, members of the board. I'm John Savage on behalf of Dotan Melik. Mr. Melik is here, and I believe the board's all familiar with Mr. Melik from the City of Nevada receivership. And
Mr. Chairman, good morning. Director Climas, board members, Dotan Melik, proposed receiver. If you have any questions.
Any questions? And likewise, as to the previous matter, do we have anyone else who wishes to statement as to?
Mr. Chairman,
Yes, good morning.
good morning. Mr. Chairman, members of the board, my name is Louis Magazoo. I'm an attorney licensed in Vineland, New Jersey. I'm the attorney for the estate. I'm here with Barbara Rubin and Shayna Indig. If I may, Mr. Chairman and members of the board, if I could have just a moment just to give you our perspective. I am a 50-year friend of Mr. Indig. We actually were friends since freshman year in high school, and we were law partners for 10 years. I have handled numerous matters on behalf of his when he was alive, and also with this estate. When we realized Mr. Indig did not have long to live, we contacted local counsel and began the process. I also, in addition to being an attorney of 40 years, have represented Columbia Care, Live Well, and Greenleaf in cannabis matters in New Jersey. Ms. Rubin has a multi-decade career experience in accounting and bookkeeping. With all due respect to the proposal of the receiver, given that we're talking a very short window, and the matter is the involvement would be mostly just to get to learn the system, learn the facility, and report back. We would respectfully request that there be a waiver of the receiver and the remedy that counsel suggested earlier with respect to Ms. Rubin, but we'd also obviously be do any type of reports that would be required by the commission. This is, again, no disrespect to the receiver, but literally we're trying to reduce costs here. And we believe that between local counsel, Ms. Indig, Ms. Rubin, and myself, the four of us would be able to fulfill the requirements to deal with the commission between now and the actual transfer of the license. So we respectfully request that consideration. We know that this is a new process for all of us, and this is a unique process. And I want to also finally add, I want to thank the commission staff for their sensitivity and professionalism throughout this process. Thank you very much, Mr. Chairman.
Thank you. Comments or questions, concerns by board members?
The Chair, if I may respond to some of those comments.
Yes, please.
We do technically have a licensee here who does not have an owner with an agent card. So staff and I believe that the receiver is necessary. Staff does need time to investigate the TOI report and determine suitability for the new owners. Maybe it's quicker than others, maybe it's not, but I don't want to shortchange Mr. Staley's team, and I want to make sure they have enough time. So again, staff believes it is appropriate to have a receiver in place with monthly reports. And hopefully the process gets done quickly, but I mean, we can't guarantee February just yet at this point.
Thank you. With any discussion by board members?
Mr. Chairman, I have a question of Mr. Rath. I'm just recollecting that, this last legislative session, this sort of circumstance was the very reason that the legislature recognized the process for a receiver. So that is in place, and I think this is the exact situation was contemplated by that legislation. So the notion of having a temporary agent card instead of a receiver, the statute doesn't really recognize that. It seems to me it's the path we were, I think, sort of statutorily ordered on was the path of a receiver, but I could be recollecting that wrong. I just wanted to get your thoughts on that.
I agree with you, Member Nylander. It was put in place for that purpose. And as you're aware, we had an earlier instance where a sole owner had passed away and we got a receiver. And at that point, and Actually, that receivership ended up being a lot longer than we had anticipated or the receiver anticipated. So again, we don't know what we're going to find as we go through these TOIs and the receivership starts. So I think it's prudent to proceed as I feel, as you do, that the legislature intended.
Yeah, and I think also we have an additional level of protection in as much as the court is also overseeing the matter. So, so thank you, Mr. Rath.
I have a question for Mr. Malik. Would you, so if you were appointed and it was just temporary because the I'm sorry, the executrix of the estate was able to become licensed, would you want to be the receiver just for a limited time, or would that be a hardship on you?
I don't believe it's a hardship. As Mr. Roth indicated, we don't know what we're gonna see when we go in.
But would
So
you be, so for, if you were appointed and in 60 days, everything turned around, she was licensed, your services weren't needed anymore, would you be perfectly willing and happy to step back and say, okay, you're now in charge?
yes, I think it's what the statute calls for, and I think that's appropriate, even if it's a short time.
Thank you.
I think there's one benefit to that, if I may add. My understanding is that your client does not have experience in the field.
Correct.
And I believe that having a receiver that has an understanding in the cannabis space, handing over some information or more information to the future licensee is helpful.
Thanks.
And if I could just follow up on that, Member Durrett, my clients have been involved with Mr. Engdig and his businesses, obviously for an extremely long time, and since the initiation of the operations back in 2014. So they are familiar with it. They certainly have participated with the investigator in preparing all of the financials and all of the suitability information. So they are extremely familiar with it, and they're cognizant of all of the applicable laws. Again, we have tremendous respect for the receiver process, understand it and the basis of it. We just wanted the board to be aware of the fact that it's a very short period of time. The estate has pretty much been resolved. There are no assets to be sold. The creditors have all been satisfied, and there's no contest of the will. And so for those reasons, again, we wanted the board to consider allowing the executrix to continue the operations in lieu of a receiver. That said, if the approval is today for us to proceed, we will file the court documents this afternoon and proceed accordingly. So I wanted the board to be assured that we understand your our obligations and the responsibilities, and we'll proceed with those if that's the board's desire.
Thank you. The record, Chair Douglas, this seems to be a timing matter. We are cautious looking at this. We appreciate the fact that everything on its face seems to be in order and is moving as the parties are representing, that there's no one coming out of the weeds and contesting the transfers and so on, but being cautious as to a privileged license. We feel that we are acting with the proper diligence. Bring this matter before this receivership. I would make a motion to receive. Hopefully, as a representative, it will be for a very short period of time, and that they will live happily thereafter. But I would make a motion for the appointment of the receiver.
I second.
Moved and second. Any additional discussion? Hearing none, all in favor, please say
Aye.
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 matter carries.
Thank you.
Thank you very much.
Thank you.
Hopefully you will have a speedy and quick process. That moves us to item number C, New Leaf Cultivation Center.
Thank you, Chair Douglas. Item 7C concerns a New Leaf Cultivation Center, license numbers C089 and RC089, and a New Leaf Production Center, license number P058. The counsel for each of the owners is present, Mr. Humphrey and Mr. Hart. And Mr. Melek is again present as the cannabis receiver applicant. By way of background on this matter, on January 12, 2022, the attorneys for the owners of A New Leaf filed a joint application and stipulation for an order appointing receiver in the Second Judicial District Court for Washoe County, Nevada. This application states that the owners, quote, agree that the management of the New Leaf entities is at an irreconcilable deadlock, and said continuing management impasse supports appointment of an equity receiver, unquote. The application further states that, quote, the New Leaf entities do not generate sufficient funds to pay the debts owed to their members and those certain specific creditors of the New Leaf entities, close quote. The application included a stipulated court order subject to CCB approval for the appointment of Mr. Melek as receiver that the parties agreed upon. It appears the court has not yet executed that stipulated order. I'll let Mr. Humphrey provide an update on that. I think it's just awaiting the judge's signature at this point. But as a result of the owner's agreement, Mr. Melek has applied with the CCB for an agent card and requested approval for placement as a cannabis receiver over the New Leaf entities. Additionally, on January 18, 2022, CCB staff performed a full audit inspection of the facilities and found no deficiencies. Again, we request that the order include a requirement for the receiver to make monthly reports on the 15th day of each month. I'll now turn this over to counsel for the owners. Mr. Humphrey's present. I believe Mr. Hart is on Zoom, and the proposed cannabis receiver, Mr. Melek, is here to make any presentations that they wish and to answer any questions of the board, after which the board may go ahead and vote on this matter.
Thank you, Mr. Rath and members of the board. The summary was correct. The members of these two entities are at a deadlock. To give a little bit of history, there's only two members of each one of these entities, and they both obtained their membership interest from a larger group. So they inherited essentially what amounts to an unworkable operating agreement that requires unanimous consent and has a lot of ambiguity in it. We are unable to resolve decisions on how to move the company forward. While all third-party creditors are paid or in the course of regular payment and not behind, the members contributed substantial advancements in equity contributions and into the company, and related companies perform services for these companies for construction, for example, that are outstanding. So the only creditors that are owed money are mostly insiders and minor trade creditors that are current. So the one thing we could agree on is that we needed help moving this forward. And so the parties did come together and discuss receivership as an alternative to litigation, and decided that Mr. Melek was a good choice from his experience in CW Nevada. Mr. Melek and his team have been up to the facilities for tours and have, I think, a substantial background knowledge on these operations. And if this is approved by the board and the court, we're ready to move forward immediately. So we thank you for your consideration. If there's any questions, we're happy to answer them. And Ms. Hart is also on the line.
Questions well, before we get to questions, do we have anyone else who wishes to speak as to this matter?
Good morning, Chair Douglas and members of the board. My name is Leslie Bryan Hart, and as Mr. Humphrey indicated, I represent Morganics LLC, a member of the two entities that are under consideration for receivership. I have nothing to add to Mr. Humphrey's description of the events that brought us here today, and I'm happy to answer any questions that you may have.
Thank you. With that being said, appropriately, questions by the board or any concerns? If there's no questions-
Mr. Chairman, this is Member Nylander. I'm just curious, the path forward. You mentioned the operating agreement was unworkable. So is that part of what the receiver would be trying to unwind?
I think what the parties decided is to independently turn it over to the receiver and allow the receiver's business judgment to move the case forward. I believe that that is definitely a possibility, that a workable operating agreement could come out of it. Also increases in profitability. So there is some language in the proposed order for receivership on the purpose of the receivership, and one of those is to increase the net profitability, because frankly, if we get to that profitability point, a lot of problems solve themselves. And so I think that's really where it's at. The companies are making enough money to pay third-party creditors, but not to return any investment upon its owners or to pay the debts of the insider creditors that have delayed payment thus far. So we believe that Mr. Malek will come in, assess the profitability. You'll probably see in the next couple of weeks a request for approval of a management agreement to put people in place. There's already discussions on that between the parties. Ms. Hart and I have worked very well together, I think, in getting it this far. And so it could have any type of outcome. It could be a buyout, membership buyout, a third-party sale, or a workout of an operating agreement that might work going forward.
Okay, that makes sense. I did note that in the proposed order. And it sounds like the parties are just at such an impasse where it's necessary to have a third party come in and do an overall evaluation and then proceed from there.
I think that's accurate. I think to avoid any litigation on the matter between the members, which we felt would be a less productive means of moving things forward than just agreeing to a receiver who can guide the company forward, because the parties can't agree on where the company goes.
Thank you.
Yeah, and no offense to all the lawyers in the room, but that seems like a reasonable approach to me. Avoid litigation.
Well, I think you have a couple of reasonable lawyers.
So hopefully it will stay that way. With that said, I will make a motion for approval of the receiver.
A second.
Been moved and seconded. Any further discussion? Hearing none. All in favor, please say aye.
Aye.
Any opposed? Any abstention? Motion carries. Thank you very much, and good luck.
Thank you, Chairman.
Thank you.
Moves us to item number 8, consideration for approval of correction action plan and lifting of summary suspension. We have one item under that. We know we have a partial sign off at this point, but we need further information.
Thank you, Chair. And for this item, agenda item number 8 here, I'd like to introduce Senior Deputy Attorney General Emily Bordelove, who will present to the board on this issue. And we also have the licensee here to answer any questions. So with that, Ms. Bordelove, when you're ready.
Thank you. Good morning, Chair and members of the board. Emily Bordelove, Senior Deputy Attorney General for the record, here to present on item 8A. On October 20th, 2021, CCB agents conducted an investigation of the Cannabis facility. The agents discovered, in pertinent part, as follows: discrepancies with the inventory of a product versus product on hand, production logs showing additional product added to runs after testing, and discrepancies between the amount of distillate Cannabis reported using and the amount of product Cannabis produced. Specifically, the amount of distillate Cannabis documented using could not yield the amount of product at the noted THC potency that Cannabis claimed it produced. On November 5th, 2021, the board held an emergency board hearing and voted to summarily suspend Cannabis, finding Cannabis posed an immediate threat to the public's health, safety, and welfare. On November 23rd, 2021, Cannabis sent the CCB its amended final plan of correction, outlining, in pertinent part, its intent to terminate all relationships with existing staff and bring in new, more qualified staffing to oversee compliance, add security, destroy the affected product, cease production of the affected product, and develop new brands, and hire a new on-site compliance officer with prior cannabis experience. During the suspension, CCB agents were on site to observe the destruction of the affected product. On December 9th, 2021, the suspension was conditionally lifted upon approval of the board, and Cannabis was permitted to resume its operation after its 34-day suspension. As Director Clemens pointed out, the licensee is here, available here to answer any questions the board may have. And with that, Chair Douglas, I turn it back to you.
Thank you. The licensee and representative.
Good morning, Chairman, members of the board and staff. For the record, I am Christina Gausin, appearing on behalf of Cannabis. I'm accompanied by the license holder Stephanie Meehan and our compliance manager Mason Cave. We appreciate your time here today as we respectfully address case number 202152 for reinstatement of Cannabis LLC cannabis production license that received a temporary summary of suspension on November 5th. In accordance with CCB guidance, we have submitted our final plan of correction November 23rd, 2021, which was then approved on December 8th, 2021. This plan of correction addresses the cited deficiencies and also implements additional measures to ensure the resolution of these issues and mitigates the possibilities of these infractions going forward. We have also acquired an in-house compliance manager, Mason Cave, as well as a compliance consultant who is a previous DOT CCB compliance auditor that will conduct regular inspections and audits to ensure Cannabis is consistently operating within the standard set forth by the Cannabis Compliance Board. Pursuant to the aforementioned resolutions, all possible action has been conducted and completed. Cannabis received an order lifting the summary suspension on December 9th. Following on December 13th, Cannabis received reinstatement of operation from the Clark County Department of Business License. In closing, we kindly request the board's consent to resume operations, formally lifting the suspension. And as a representative of Cannabis, I'm here to answer any questions you may have.
Thank you. Board members? Dennis, we're not hearing you at this point.
Mr. Chairman, this is Member Nylander. Is a quick question, is the compliance officer a full-time position?
It's not full-time, so I'm here and available weekly, and we have weekly reports that we submitted in the plan that we conduct weekly.
Okay, thank you.
We do have on-site assistant compliance as well.
Did you not have a compliance person before?
The previous individual we entrusted with compliance is no longer with us as a result of these actions.
Sorry, I think I remember reading that now. Okay, thank you.
Reviewing the matter for us, indication you basically had a complete staff turnover basically to bring yourself up to speed and to stay compliance. With outline of programs to make sure that your staff is doing things pursuant to the rules and regulations. Questions, concerns, anything additional? That being the case, understanding that our staff is still reviewing this, with that, if we can have a motion.
I move to approve the corrective action plan and lifting of the summary suspension. The call for action. Motion is okay. Under agenda item 8A.
We have a motion. Do we have a second?
Second.
Been moved and seconded. Any additional discussion? Hearing none, then all in favor, please say aye.
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 Motion carries. Thank you very much and good luck.
Thank you for your time.
We won't see you again on this.
No.
Thank you.
Item number 9, consideration of stipulation order to dismiss prejudice. One item, item A, as Zion Gardens.
Good morning, Chair. For the record, Ashley Balducci, Senior Deputy Attorney General. Item 9A is a stipulation order to dismiss with prejudice that resolves litigation against the Cannabis Compliance Board and other named state officials and agencies filed in the 8th Judicial District Court. If approved, the litigation in case number A-21-844814-C will be dismissed with prejudice. Unless the board has any questions, I would request that the board approve item 9A.
Good morning. This is Attorney Ben Lahavi on behalf of Zion Gardens, and I'm here with my co-counsel, Attorney Jessica Shimoda-Guerra. We are in favor of the settlement and dismissal.
Thank you. Board members, any questions, discussion, concerns? I'd make the motion to accept the stipulation of dismissal of prejudice.
A second?
I'll
Moved
second
and
that.
second, any additional discussion? Hearing none, all in favor, please say aye.
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 Any dissent or abstentions? Matter carries. Thank you.
Thank you, Chair Douglas.
As indicated in the meeting, item number 10, which was consideration of proposed amendment and or additions to Nevada cannabis regulations, has been removed from this agenda for further study by the board and consideration of various comment from public. With that, we would move to item number 11, consideration for approval to extend the February 5, 2022 final inspection deadline. If we can have our staff preliminary presentation so that we can possibly group these and expedite them.
Chair, thank you. And Chief Gilbert, before you get started, and Chief Gilbert will handle these. We have another large chunk, as the board can see, but I'd just like to take a moment to thank Chief Gilbert and his team. This ended up being quite the monumental task. There are still more, but this should help us resolve most of the remaining issues with the extension request. And so, as you indicated, Chair, there is an opportunity here to take some in block. Chief Gilbert, I'll let you explain that, and when you're ready, you can go ahead. Thanks.
Thank you, Director Klimas. Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. I'm here today to present agenda item 11, which consists of requests submitted by conditional licensees to extend the February 5th, 2022 deadline to receive a final inspection by the CCB. Before I go into the extensions, and if it's okay with the chair, I would like to provide a brief update on the extensions received to date and the number of conditional licensees that have not submitted a request for an extension of the February 5th, 2022 deadline. I'll provide a brief timeline of what's transpired since October 12th of 2020. On October 12th, 2020, the CCB sent a letter to 72 entities, which represented 145 individual licenses, providing notice of the February 5th, 2022 deadline. On November 10th, 2021, the CCB sent a listserv to the same entities advising that any request for an extension of the February 5th, 2022 deadline must be received by the CCB no later than December 31st, 2021. 37 entities representing 78 licenses submitted a request to extend the final inspection by the December 31st, 2021 deadline. 5 entities representing 6 licenses submitted a request to the CCB after the December 31st, 2021 deadline. A total of 42 entities representing 84 licenses submitted extension requests. The board has granted 41 individual license extension requests through the December 2021 board meeting. There are 41 individual license extension requests on today's agenda. 6 extension requests are undergoing review and will be scheduled on future board meetings agendas. So in summary, 19 entities representing 20 individual licenses have not submitted an extension request. Some of the original 145 licenses that originally received the letter in 2020 have already received their final inspection or received final licensure, so an extension request wasn't necessary. And I'd like to take this opportunity to acknowledge and thank Marilyn Gray and Ingrid Byrulen for all their efforts and hard work to process these requests. Unless the board has any questions or comments, I can begin going through the individual requests.
At this time, there's no additional questions. I know there's a comment we'll make at the end of this presentation. The member who wished to make that comment has stepped out of the room. We will come back to this because we do have some concerns as to licensing extensions, future action who have not made the request. She's back. Probably a good time before we get into this. Make your ask.
Oh, okay. Thank you, Chair. I wanted to ask if at some point on the agenda, we could get a discussion of the term extenuating circumstances. I don't know that we would want to take action because, and I don't know we'd want to develop a regulation because we want to leave that pretty broad, but maybe at least have a discussion of it. And maybe we would want to develop a regulation on it because right now, it's pretty open to interpretation, and I think maybe a little guidance on extenuating circumstances would be helpful.
And with that, just adding, as my comment was, as indicated, we have another group that has bothered to contact us either timely or prior to this meeting, after the fact, as an extension. And we understand our action is us in this place. If they have anything vested or not vested that we need to proceed with. So that would be our ask to the board. But with that, we need to, going back to staff, if there's any way we can categorize some of these, so we can take a group or not a group and to try to expedite, because we are used up the alphabet slightly with the number A through Z. Some of them make sense because of the moratoriums in certain counties. Others have moratoriums in cities. And then we have some delays because of location issues, churches, other variance items that have changed on them during the process. The delay created by COVID and materials. So with that, I throw it back at staff.
Thank you, Chair. Items A through I involve entities that are settling parties to either the July 2020 or August 2020 settlement agreement, which granted a 14-month extension to these settling parties, with conditional licenses in jurisdictions with moratoriums on new adult use cannabis establishments to obtain a final inspection and approval from the CCB. Because items A through I a request for an extension in a county with a moratorium on cannabis establishments, would the board prefer to take these all together or individually? Representatives from each entity are present today if you would like to hear from any specific one. Again, that's agenda items A through I.
Noting on item, if for the record, if we have council representatives on items A through H, Greenmount, Lone Mountain, TRNV 098, TRNV PO98 LLCs, one for Lander, one for Pershing, Congeria, out of Henderson, Reno, Lincoln, and Eureka. If their representative council just wants to state their name for the record and their representation.
Good morning, Chairman Douglas, Director Climas, and members of the board. I'm Maggie McCletchy here on behalf of Green Martin Nevada NLV LLC.
Good morning, Chairman, members of the board. Amanda Connor on behalf of Lone Mountain Partners LLC.
Good morning, Adam Fulton on behalf of Conjurium 1, 2, 4, 5, and 3.
Good morning, Shane Terry on behalf of TRNB P098 LLC.
Thank you. I mentioned A through H. My reading, unless I was mistaken, we don't have a moratorium on Conjuring 3 and Esmeralda. There was at least I noted a building in progress issue.
That is correct.
And how is that proceeding?
It's proceeding well. My client was able to locate land. They were able to secure a lease. We had some construction issues. We've got Paul Thomas here, a representative of Conjurium, with me if you have any specific questions regarding the build out. But they were able to actually do all the groundwork, and the walls are up right now. The roof is on, and we're getting close to being able to complete the construction. We're real close.
Board members asked that particular many questions. I would make a motion for approval. And what we're looking at for our bookkeeping purposes and uniformity, because we have various people who are asking 6 months or 14 months. My motion would be to grant a 12-month extension. If you get it done faster, that's great. And for the other ones, it's a 12-month in A through I.
Chairman, I missed bringing this up before we got into the discussion. A quick disclosure that Mr. Fulton represents my mother in some business litigation. It should be settled any day now, so I won't need to keep making this disclosure. Thank you. I will proceed because a reasonable person with independent judgment in my position would proceed.
I thank you for that, and your statement, you're a reasonable person. With that, if we can have a motion, a 12 extension as to items A through I. I make a motion for approval of those items.
I second.
It's been moved and seconded. Any additional discussion as to A through I? Hearing none, all in favor, please say aye.
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 Aye. Motion carries. A through I, granted for a month extension.
Thank you.
Continuing on, do we have any other we can consider?
Not at this point. I will point out as we go through the rest of the agenda items, if one falls into a similar entity, and I'll point that out as we go, that we could take probably the one or two at the same time.
All right, that would then move us to item number J, Two Skirts Cultivation Production.
Thank you, Chair. Agenda item J is for Two Skirts Cultivation and Production, LLC C190, RC190, P125, and RP125. Two Skirts Cultivation and Production, LLC requests an extension of the February 5th, 2022 deadline for a period of 6 months to perfect its conditional medical and adult use cultivation and production licenses, C190, RC190, P125, and RP125. All within the Fernley jurisdiction. In this request, Two Skirts reported on its accomplishments made in perfecting its licenses, but is still dealing with supply chain issues as a result of COVID. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Adam Fulton is present and Madeline Castar is present via Zoom to give a brief presentation and address any questions you may have as well.
Good morning.
Good morning. Adam Fulton again for the record. So this entity has been in the process of attempting to open a facility in Fernley, Nevada. They have spent a significant amount of money and time trying to open the facility. They were able to locate one. They've opened, but they've spent a lot of time on the build out, and they did run into some issues getting certain materials in to complete the construction. This was a group effort by the owner. And then there was a TOI submitted for this one back in January of 2021 to transfer the ownership that's still pending. And we are waiting on approval of that. And there also is a pending management agreement that's also been submitted for approval as well. And if you have any questions for us, we're happy to answer them. I'm going to have Madeline Castor, who is attending via Zoom as well, remotely.
Any questions as to Two Skirts 12-month extension? If not, we can have a motion.
I move to approve the extension request submitted by Two Skirts Cultivation and Production. The extension would be until February 5th, 2023.
We have a motion. Do we have a second?
Second.
It's been moved and seconded. Any additional discussion? All in favor of the 12-month extension of Two Skirts, please say aye.
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 Any opposed? Motion carries.
Thank you.
We go to item A, ETW Management Group.
Agenda item K is for ETW Management Group LLC, RC023. ETW Management Group LLC requests an extension of the February 5th, 2022 deadline for an additional 12 months period to perfect its conditional adult use cultivation license RC023 within the Henderson jurisdiction. ETW has made progress, but is involved in a lawsuit with the management company at the establishment site and is dealing with a distance separation issue with the city of Henderson and may need to relocate to a new site. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Adam Fulton and Paul Thomas are present to give a brief presentation and address any questions you may have.
Adam Fulton again on behalf of ETW, and Mr. Paul Thomas is here today as well. This one's been an interesting one because we had perfected medical, and then when Mr. Thomas acquired the building, it was zoned correctly and approved for cultivation. The association, after the purchase, then changed the CC&Rs to prevent cultivation. The litigation's been ongoing since 2019. We subsequently then moved it to a new location to try to meet the deadline of February 5th. But after we moved it to a new location, City of Henderson did a distance survey and found that it was a suitable location. We then came back and found a church that they had missed on the previous go around. So now we're trying to figure out if that church is even a real church. We're trying to figure out what's going on there. But Mr. Thomas has done everything he can to try to perfect this license. And so we're requesting an extension for the 1 year as stated by Mr. Gilbert. Thank you.
Questions of council or licensee as to the ATW? If we have no questions, since this is something that is allowable under the Henderson ordinance, if we can, I would move for a 12-month extension for ET.
I second.
Second.
Moved and seconded. Any additional discussion? Hearing none, all in favor of approval, please say aye.
Aye.
Any opposed? Any opposed? Matter carries.
Thank you.
Moves us to item number L. ABC
Agenda
Nevada.
item. Sorry, Chair. Agenda item L is for ABC NV LLC RC 120. ABC NV LLC requests an extension of the February 5th, 2022 deadline for a period of 12 months to perfect its conditional adult use cultivation license RC 120 within the Clark County jurisdiction. ABCNV began taking steps to perfect this license prior to CCB's approval of TOI, which transferred the license from the previous owner in December of 2021. The established Pepper Lane Holdings LLC to purchase a building in Las Vegas and has taken a number of steps to advance while awaiting approval of a special use permit application at the January Clark County Board of Commissions meeting. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Adam Fulton and Jeffrey Nassif are present to give a brief presentation and address any questions you may have.
Thank you, board members. I figured I'd just stay up again this time. Adam Fulton, again, appearing on behalf of ABC, and I have Mr. Bill Moore here today, who's representative of ABC. This entity, as Mr. Gilbert said, was transferred. The ownership was transferred in December. And we are in the process of obtaining an SUP. It's been a little bit of a hurdle working with the county, but we're trying to work through that to get the SUP wrapped up so that we can begin operations. We're hopeful that we can get that done. Actually, we're on the agenda for the first of February, February 2nd, excuse me. And so we're hopeful to get the SUP, and then we will complete construction and begin operations.
No, for the record, this location is in Park County. Questions? If there's no questions, then I would make a motion for the 12-month extension.
Second.
Moved and seconded. Any additional discussion? All in favor, please say aye.
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 Aye. Any abstentions? Denials? Matter carries. Thank you.
All right. Thank you very much. We'd like to also thank staff for their assistance in this matter. We appreciate their hard work. Thank you.
That moves us to item number M, TRNV P098. This is in Mineral County.
Thank you, Chair. Agenda item M is for TRNVP 098 LLC RD 673. TRNVP 098 requests an extension of the February 5th, 2022 deadline for its conditional adult use retail store license until March 30th, 2023, or 14 months after Mineral County adopts business licensing regulations, whichever is later. Although Mineral County allows for medical dispensaries in certain zoning districts, the county has no regulation allowing for retail-only dispensaries. The Mineral County representative indicated to CC staff that getting a special use permit would be difficult due to concerns from its residents. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Shane Terry is present to give a brief presentation and address any questions you may have.
Identify yourself and statement, sir.
Good morning. My name is Shane Terry from TRNVP 098 LLC. And we've been in communication periodically with Mineral County staff. And like Mr. Gilbert mentioned, they do have some provisions for medical dispensaries as well as cultivation and production. So we're hopeful that that this might change in the near future. We're working on lobbying up in the staff, and I guess we'll just have to keep you up to date as we make some progress.
It indicated you were had a possible site by Walker Lake.
Yes, sir. It seems like if they were to adopt regulation, they were saying that they would probably not want it in the city of Hawthorne and a little bit north, closer to Walker Lake. But again, that would still be dependent on final approval and what the rest of the commission decides to adopt.
Questions, concerns by board members?
So this is member Nylander. There is no moratorium, it sounds like, but the other surrounding approvals you might need would be difficult to obtain. But it's not an actual moratorium, is that right?
No, sir. It's our understanding that there is no specific moratorium, but they also have not moved to adopt regulations that would permit it.
Okay, but you see some opportunity maybe in the Walker Lake area to find a location that might be able to get through the city.
We're hopeful, but it seems, of course, that's what we received from staff, some indication that if they were to adopt it, that would be the area that would be most promising. But again, I think that's probably just a limited opinion to a few of the staff members.
Okay, thank you for that clarification.
Welcome, sir.
Chairman, can I ask to add 2 more pieces of information to our growing list on how we're going to deal with these extensions when they come back up. One, is it possible to get a list of which jurisdictions, and I know this isn't one of them, which jurisdictions issued moratoriums and notices that they would not allow licenses? Which jurisdictions did that before the application period? And then a status on, I think the first one we dealt with a local ban was Elko, I think, and they were about to file in district court that the ban was violated the initiative petition. Can we get a status on that case? And maybe, or actually, I mean, I would be happy to look it up myself. I just need a reminder of the parties. But I think that will be very instrumental in a lot of these cases. If the court determines locals can't do bans, then the extensions will take a different turn. If the court determines there's no right to have a license in a local jurisdiction that bans it, then that'll, I think, be meaningful. Thanks.
I have a comment, but we'll deal with this item first. As to this, we understand that the difficulties that you're having in that locality. At this time, the motion extension, 12-month extension. With this, hopefully, it can be resolved. That if not, please come back. Having said that, do we have a second?
Second.
Any additional discussion? All in favor of 12-month extension, item M as the TRNVP 098, please say aye.
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 Any opposed? Any abstention? Matter carries. Thank you.
Thank you.
Yeah, I would just note for the record that we have some that have a complete ban. We have others, a few others who've technically permitted it, but they make their zone almost impossible to find location. So your concern so very warranted in terms of getting a lay of the land. That moves us to item N, Lone Mountain LLC, RD 601. That's Mineral County. That was something came from settlement agreement. Staff.
Agenda. Item N is for Lone Mountain LLC RD 601. Lone Mountain requests an extension of the February 5th, 2022 deadline for its conditional adult use retail license RD 601 within the Mineral County jurisdiction for an additional 14 months. Mineral County allows for medical dispensaries in certain zoning districts, but the county has no regulation allowing for retail-only dispensaries. The Mineral County representative indicated to CCB staff that getting a special use permit would be difficult due to concerns from its residents. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Derek and Amanda Connor are present and James Leventis via Zoom to give a brief presentation and address any questions you may have.
Good morning.
Good morning, Chairman, members of the board. Via Zoom is James Leventis, who can also address any questions. Also, as Mr. Gilbert indicated, my husband, Mr. Connor, is also here, who is the point of contact. We would kindly request that an extension be granted. As Mr. Gilbert covered, they do allow medical dispensaries, but do not have code or regulation in place for recreational or retail stores. We are here to answer any questions that you may have.
Thank you. As of this matter, we're aware of the settlement agreement in 14 months. For purposes of this ease of keeping track of settlement agreements, our motion is for 12 months at this time. With that, that would be my recommendation. Motion.
A second.
Move the second. Any additional discussion? Hearing none, all in favor of the 12 months for Lone Mountain LLC, please say aye.
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 Any person aye or abstentions? Hearing none, motion carries.
Thank you.
Thank you. Moves us to item number O, BBMC LLC, T014. That's in county. Staff, please.
BBMC, I'm sorry, agenda item 0. O is for BBMC LLC T014. BBMC LLC requests an extension of the February 5th, 2022 deadline for an additional 12 months for its conditional adult use distribution license T014 within the Clark County jurisdiction. BBMC has submitted transfer of interest requests to the CCB and is waiting for those to be processed. At the December 14th, 2022 CCB board meeting, the board sent 2 of those transfers of interest back to CCB staff for further research and information gathering so they could better understand the complex issues associated with the said transfers. As a result, BBMC is unable to comply with the February 5th, 2022 deadline. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Derek Connor and Robert Frey are present to give a brief presentation and address any questions you may have.
Good morning, Chairman. Thank you, Mr. Gilbert. I have Mr. Connor here as well. We are here to answer any questions you have. As Mr. Gilbert covered, this is a distribution license. They did work originally with Department of Tax staff and with Cannabis Compliance Board staff. They have the facility and everything ready, but due to issues with the pending transfer of interest, have not been able to finalize this license. Therefore, we kindly request a 12-month extension.
What, from a staff standpoint, do we have a resolution coming up of this TOI coming before us soon?
Chair, this is Executive Director Climate. We're still working through those issues. So there's not a time frame currently. So we believe a 12-month extension would be appropriate.
Other members of the board, questions? If not, can we have a motion for appropriation?
Move to approve the request for an extension under agenda item 11O submitted by BBMC. The extension would be 12 months from February 5th, 2022.
Second.
Moved and seconded. Any additional discussion? Hearing none, all in favor of 12-month extension, say aye.
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 Motion carries. Thank you very much.
Thank you.
That moves us to item number P, Essence Tropicana. That's in the city of Las Vegas. Staff,
Agenda
please.
item P is for Essence Tropicana LLC RD 317. Essence Tropicana LLC requests an extension of the February 5th, 2022 deadline for its conditional adult use retail store license RD 317 in the Las Vegas jurisdiction for an additional 12 months. After identifying a site and obtaining a special use permit from the city of Las Vegas, Essence and the property's landlord were unable to negotiate a material lease, requiring Essence to locate to a new site. Finding a suitable location which meets local and state requirements has been difficult, with the COVID pandemic adding to the difficulties. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Amanda Connor, Brendan Bloom are present to give a brief presentation and address any questions you may have.
Good morning.
Good morning, Chairman, members of the board. I have with me Brendan Bloom from Green Thumb Industries, the parent company of Essence Tropicana. As Mr. Gilbert indicated, they have been working to find a location and in fact had received special use permit approval for a location, but then the material terms of the lease could not be finalized and they were forced to look elsewhere. They are diligently working to identify the location, have been working with city staff in business licensing and other things to continue to move this forward. We kindly request approval of a 12-month extension.
Questions of either staff or the applicants? For the record, Chair Douglas, we're noting between the complexities of zoning and also a secondary economic capitalism issue, landlords playing games with prospective licensees as to cost of locations and changing terms. This is becoming a recurring issue. Having said that, under the circumstances, it's in a jurisdiction that allows for it to be licensed, just a matter of location. And they have been diligent in the process of a 12-month extension.
Second.
Moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye.
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 Any abstentions? Denials? That carries. Thank you.
Thank you.
Thank you.
We move now to item number Q. MMR and D LLC 0208 and P 138. That's in the Fallon. We can have our
Agenda item Q is for MMR&D LLC C 208 P 138 and RD 098. MMR&D LLC requests an extension of the February 5th, 2022 deadline for its medical cultivation and production and adult use retail store licenses within the city of Fallon jurisdiction. It did not indicate a specific amount of time in its request. MMR&D is working to show the city local support for its medical and adult use licenses and has retained a government affairs professional to work with the city. Fallon's 9 land use districts prohibit cultivation, production, manufacturing, and non-medical retail stores. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Nathan Van Treese and Danielle Guiducci are present to give a brief presentation and address any questions you may have. They're present here in Carson City.
Good morning, Chairman
Licensee.
and members of the board. My name is Daniel Judici, representing MMR&D. With me today is Nathan Van Treese, one of the owners of MMR&D. As mentioned, Fallon has a moratorium on both cultivation, production, and retail dispensary. We would request a 14-month extension. We do believe that there is progress being made in the city of Fallon, and with this extension, they will activate these licenses. And we're available for any questions.
Questions by the board as to MMR&D's location in Fallon? Hearing no questions, I'd make a recommendation. I know they're asking 14 months, but as indicated, we're granting 12 months this time for a 12-month extension. Hopefully they can facilitate a location.
Second.
Been moved and seconded as to item number Q for approval of 12-month extension. In favor, please say aye.
Aye.
Any opposed?
Aye.
Aye.
Any abstentions? Matter carries. Thank you. That would
Thank you.
then take us to item R, which is MMR&D LLC as to Fernley. Staff, please.
Thank you, Chair. Agenda item R is for MMR&D LLC C 209 and P 139. MMR&D requests an extension of the February 5th, 2022 deadline for its medical cultivation and production licenses within the city of Fernley jurisdiction. It did not indicate a specific amount of time in its request. The pandemic shutdown hindered its ability to work with the city of Fernley and its ability to search for a suitable site. When a site was chosen, negotiations began on a lease with the property management company. MMR&D reports that the landowner has expressed approval for leasing the property to MMR&D. Once the lease is executed, MMR&D can proceed with the special use permit application process. Staff have identified new areas of concerns, and again, I'm available for any questions. And Nathan Van Treese and Danielle Ducci are still present to give a presentation and address any questions you may have.
Again, for the record, Daniel Judici representing MMR&D with Nathan Van Trees. As it pertains to the city of Fernley, we did identify an area to lease, have entered into negotiations with the landlord. There was a death in the landlord's family that has extended these negotiations. We do believe we should enter into the lease within this month, and we'll provide that lease to the CCB.
Questions by the board?
May I make a comment, Chair? On it's not necessarily this license, but just a comment that going forward, I will be mindful of licenses that look like they're developing in good faith versus licenses that are hanging on to this license to sell to the highest bidder, because that's a business decision. That's not extenuating circumstances and really violates the spirit of the entire program and is unfair to other licensees. That's not necessarily this license.
Any other comments? And if not, if we can have a motion to this particular item.
I move to approve agenda item 6R submitted by MMR&D requesting an extension. As the chair stated, we are inclined to do 12-month extensions to keep everything consistent. So the extension would be to February 5th, 2023.
I second it.
We have a motion. We have a second as to MR&D LLC, C209 and P139 in Fernley. All in favor, please say aye.
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 Abstentions? Any denials? Matter carries. 12-month extension. Thank you.
Thank you.
Item S, Harvest Nevada LLC, C205, RC205, P136, and RP136 is in West Wendover.
Agenda item S is for Harvest in Nevada, LLC, C025, RC205, P136, and RP136. Harvest Nevada LLC requests an extension of the February 5th, 2022 deadline for its medical and adult use cultivation and production licenses in the West Wendover jurisdiction for an additional 12 months. Harvest of Nevada state's construction and budgetary expectations have been affected due to the COVID-19 pandemic, as well as the Department of Taxation's litigation impeding Harvest of Nevada's negotiations with potential partners. Harvest or West Wendover uses a third-party receiver for local requirements, which has made the approval process even more lengthy. Harvest of Nevada also indicated sourcing of building materials have been delayed. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Alicia Ashcraft is present to give a brief presentation and address any questions you may have.
Good morning again, Chair and board members. Alicia Ashcraft on behalf of Harvest of Nevada. Significant progress has been made on these facilities and significant amounts expended to date. They are probably pursuant to the construction schedule that was included in our request, are probably about 7-8 months out from being completed, despite the challenges that Mr. Gilbert just outlined. We would, out of an abundance of caution and for consistency's sake, request respectfully the 12-month extension for completion on the licenses.
Thank you. Questions?
Mr. Chairman, this is Member Nylander. Ms. Ashcraft, based on your experience, this notion of contracting with a third party out of state to review zoning types of is this something you've seen before? It looks new to me.
It's rare, Member Nylander. I think that just for efficiency and cost sake, it's outsourced, and sometimes these companies are out of state to review building plans and zoning matters, especially in these rural jurisdictions. But I agree with you. I've rarely seen it, but it does cause some issues, especially when you have other challenges and information and infrastructure going on. So it's presented kind of a unique situation in this instance.
Understood. Thank you.
Other questions? If we can get a motion as to harvest of Nevada.
I move to approve agenda item 11S submitted by Harvest of Nevada LLC. The board will approve grants and extension to February 5th, 2023.
We have a second.
Second.
Second. Mayor. All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? Matter carries. Thank you.
Thank you so much.
That moves us to item number T, FTLB LLC C210 P140 for possible action. That's Esmeralda County.
Agenda item T is for FTLB LLC C210 P140. FTLB LLC requests an extension of the February 5th, 2022 deadline for its medical cultivation and production licenses in Esmeralda County jurisdiction. It is requesting an additional 12 months. FTLB reported experiencing significant delays and circumstances after the initial location was determined to be unsuitable by the local jurisdiction. An alternate second site received initial approval by Esmeralda County, but FTLB was later advised to seek a third site. FTLB received land use approval on the third location, only to learn later that the address was not valid, causing FTLB to request another hearing and go through the process again. This site will require significant off-site improvements. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Alicia Ashcraft is present and Heather Wilson via Zoom to give a brief presentation and address any questions you may have.
Good morning again, Alicia Ashcraft on behalf of FTLB. Some of these occurrences would be comical if it weren't in their interest to get completed. There were challenges, new locations had to be found, and then we had a discrepancy as to whether the local jurisdiction wanted the address to be on one street or the cross street. And we ended up having to change it. Nonetheless, Ms. Wilson, who is available if you have any questions, was able to procure a temporary portable structure that's been moved to the location. We are actually in preliminary walkthrough inspections virtually with the CCB right now, and anticipate that we will be able to complete operational status for that location with that temporary portable building within the next couple of months. So efforts are being made to get this completed as quickly as possible. Nonetheless, we would, again, out of an abundance of caution and for consistency, request a 12-month extension to reach operational status on this location. Again, happy to answer any questions you have.
And we are still in both.
Yes, we are still in Goldfield.
Questions, discussions?
And
Ms.
anyone is
Ashcraft?
welcome. I'm sorry, I was just going to say anyone is welcome to come out to Goldfield for the final inspections if you'd like. It's a lovely trip and a nice area.
Ms. Ashcraft, is this in town or is it outside off the highway?
It's a little bit outside, yes. Which is why the off-sites are a little bit of a challenge because we have to bring utilities and whatnot to the development of the location.
Thank you.
With that, any other questions? And passing to Goldfield is a nice drive. Having said that, do we have a motion?
I move to approve agenda item 11T submitted by FTLB LLC. If approved, the board would grant an extension to February 5th, 2023.
Second.
We have a motion, we have a second. Any additional discussion? Hearing none, all in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? Matter carries, 12-month extension.
Thanks so much.
That moves us to item U, Moms Meds Management LLC, C203 and P135. And we are in Mineral County, Hawthorne.
Mom's Med Management LLC requests an extension of the February 5th, 2022 deadline for an additional 12 months for its medical cultivation and production license in the Mineral County jurisdiction. Mom's Meds identified a property and received a special use permit in October of 2019. After working to develop the property, it was determined there were too many significant challenges due to no on-site wet and dry utilities. A new site was chosen for which a special use permit was granted in June of 2021. Mom's Meds entered into a purchase and sale agreement for the property. Mom's Med is currently retrofitting the existing structures on the site. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Jeff Donato is present to give a brief presentation and address any questions you may have.
Thank you. Good morning.
Good morning, Mr. Chairman, members of the board. Jeff Donato here with Argentum on behalf of Mom's Meds, which is the licensee. We are here today seeking your approval to extend the deadline to become operational for the licensee's medical provisional certificate, C203 for cultivation, and medical provisional certificate for production, P135. As indicated in our written request submitted with the CCB, the licensee has had a number of issues and difficulties to overcome in an effort to become operational. To begin, the initial property to be used for the establishments did not have any utilities, the off-site work wasn't completed, and there were no physical structures built on the property. As a result, the licensee didn't believe the initial property would allow the establishments to be operational by the February 5th deadline, and decided to find another property that would give the licensee the best opportunity to meet the deadline. Upon locating another property, we submitted an application with the local jurisdiction to obtain the necessary land use approvals to allow the cultivation and production uses to be conducted on the new property. On June 9th, 2021, we successfully secured the land use approvals from the local jurisdiction. Once we secured the land use approvals, we submitted an application with the CCB to relocate the provisional certificates to the new property. On September 9th, 2021, the CCB approved the request to relocate the certificates to the new property. Since obtaining the approval to relocate, the licensee has been working diligently to complete its improvements to the existing structures on the property. The interior improvements have been completed and currently working on finishing up the exterior improvements, which is just points of concrete to comply with ADA requirements. The licensee anticipated having the CAO already, but due to some weather delays and the like, it is taking longer than expected. However, it's my understanding the CAO is now expected by the first week of February. As soon as we have the CAO in hand, we can provide the CCB the necessary items needed to call for our pre-opening and final inspections for the establishments. Although being so close to the finish line of becoming operational, the licensee will need some additional time to complete and pass mandatory final inspection. As such, we are requesting a 12-month extension to become operational. With that, I'm here to answer any questions you may have.
Questions by board members? No questions? Motion.
I move to approve agenda item 11U, the request from Mom's Meds Management for an extension. If approved, the board would extend to February 5th, 2023.
And I second it.
Moved and second. Any further discussion? Hearing none, all in favor of the 12-month extension, please say aye.
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 Any dissents? Any abstentions? Hearing none, matter carries. Thank you.
Thank you. We appreciate that. I'd like to thank Chief Gilbert and his staff for their hard work on the extension request. Thank you.
Item V, NevCan LLC, matters C056 and C056, and it's in Las Vegas. We have some building delays.
Hello, I'm Jeremy Eunice, point of contact for the.
Have our staff, please.
Sorry.
Thank you, Chair. Agenda item V is for NevCan LLC C056 and RC056. Nefcan LLC requests an extension of the February 5th, 2022 deadline for its adult use cultivation license in the Las Vegas jurisdiction. It did not request a specific period of time, but indicated it expects to complete construction by the end of June of 2022. Nefcan has incurred unexpected delays due to the global supply chain issues, which affected the overseas fabrication of equipment to be used in the facility. Labor has also been a challenge along with material escalation. Nefcan has made adjustments due to these delays, including fast-track construction, prepayment of construction funds, and pre-purchase of locally obtained building materials. Staff have identified no areas of concerns. I'm available for any questions. My understanding is that Jeremy Yanis is present to give a brief presentation and address any questions you may have.
Thank you. Now, sir.
Hello, members of the board. I'm Jeremy Eunice, RC056 point of contact. This is our architect on the project, Rob Gertison.
Hi, and I'll be speaking on behalf and answering any questions that the board has. Just some comments about our project. We're very excited to be completed. We've got about 43% of our construction budget already spent. We're looking to finish up. We've had three major setbacks. One obviously is a supply chain that we've incurred with mechanical units, switch gear, things like that. The second thing that we wanted to bring up, just to be very transparent, is we had some internal issues amongst construction that we have rectified right now, and we're looking forward to moving forward. The third item is we had a hiccup with planning and also with traffic. As of January 20th, we resolved that with staff, City of Las Vegas. They were very proactive in helping us. They know that we're going to be able to finish the project, and we're here today to ask that we are able to finish the project.
Where specifically is the proposed site, and what is your rough timeline, expected completion?
Our timeline, we're told that's early third quarter of this year. However, we're here today to ask that we extend it to maybe 12 months. That way we don't run into any more unforeseen hiccups. And that way we're not in front of the board asking for an extension of time again.
City.
City of Las Vegas, near the Arts District.
Other questions or discussion by board members?
I have a question. It says that you're depositing funds for construction into a voucher account. Have you already done that?
Yeah, voucher account has been set up and funds have been put in.
Is sufficient funds to cover the rest of the project?
Not all the funds have been put in, but enough has been to get us to the next stage to finish out the project. Everything trickles down, but we're very confident that we're going to finish the project.
Any other board member have questions? If not, can we have a motion?
Member Durrett, I move to approve item 11B. The request for an extension, if approved, would be granted to February 5th, 2023.
We have a motion. Do we have a second?
Second.
A motion. We have a second. Any additional discussions or questions? Hearing none, all in favor, please say aye.
Aye.
Aye. Any dissenting? Any abstentions? Hearing none, matter carries. Thank you and good luck.
Thank you.
Yeah, thank you very much.
We move to item W, Polaris Wellness Center LLC, RD 636. We're back in Esmeralda County and Goldfield.
Agenda item W is for Polaris Wellness Center LLC, RD 636. Polaris Wellness Center requests an extension of 12 additional months to the February 5th, 2022 deadline for its adult use retail store license in RD 636 in Esmeralda jurisdiction. Polaris indicates Esmeralda County has had very few actionable agenda items on its Board of County Commissioner meeting agenda since 2017, making it difficult to get local jurisdiction approvals. Polaris is currently in negotiations on a lease of another property and plans to seek approval in a future county commission meeting. Staff have identified no areas of concerns. I'm available for any questions. And my understanding is that Peter Ishak and Rusty Graff are present today to give a brief presentation and address any questions you may have.
Good morning. Good morning, Chair Douglas, members of the board, Director Klemus. My name is Rusty Graff. I'm representing Polaris Wellness with Peter Eist. This is one of those instances in a rural county where there's been problems caused by lack of infrastructure in that rural county. Also COVID issues, also supply chain issues. We had a previously approved site that another approved extension here this morning had tried to use and didn't get approved on it. But we've got a new site that is supposedly going to be approved. We've got a lease. We've got contracts to have the temporary building installed within the next couple of months. So we're asking for a 12-month extension, and we're here to answer any questions if you have any.
Thank you. Questions, comments by board members? As the question before was put forth, is that in Goldfield proper, so to speak, or is that right outside of?
No, sir. It's actually in Tonopah, right outside of Goldfield.
Question members? If not, if we have a motion.
Move to approve agenda item 11W submitted by Polaris Wellness Center. If granted, the extension would be approved to February 5th, 2023.
Thank you. Do we have a second?
Second.
Moved and seconded. Any additional discussion? All in favor, please say aye.
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 Aye. Aye. Any nays? Any abstentions? Matter carries. Thank you. Well,
Thank you.
now move to item X, MM Development Company, Inc., T077, which is in Park County.
Agenda item X is for Development Company T077. Development Company requests a 4-month extension of the February 5th, 2022 deadline for its distribution license in the Clark County jurisdiction. When applying to add its conditional distribution license onto the business license for its cultivation and production facility, Development learned through a proximity survey that it was within 1,500 feet of an establishment holding a non-restricted gaming license. It also learned that it would need to go through a separate special use permit hearing. As a result, Development has since engaged counsel to expedite submitting a special use permit application at the location of one of its other licenses. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Leighton Kohler and Stacy Truesdale Michaels are present to give a brief presentation and address any questions you may have as well.
Thank you. Good morning.
Good morning, Chair. Good morning, members. Leighton Kohler on behalf of Development Company, the licensee. With me is Stacy Truesdale Michaels. We've engaged Stacy and her firm to assist us with filing the SUP application at one of our other licensed facilities. Towards the end of last year, I began a business licensing application process that we anticipated would be very smooth and easy. We have an existing cultivation and production facility off of 4801 West Bell Drive. And there was a distribution license attached to that facility. When I went to activate that distribution license with Clark County, we learned that there was no SUP that had been ever been filed back into 2017 with the original SUPs for cultivation production activities. As a result of that, we conducted a proximity survey and learned that we were within 1,500 feet of Orleans Casino. And when this was originally approved, the 1,500-foot setback rule was not in place for those uses at that facility. So nearby, we have RD 215, which is the medicine dispensary, and we would like to move T077 over there. As part of that, we have now submitted for SUP application to Clark County, and we're going to go through the public hearing process on that, and that just takes some time to do. So we request an extension, very short extension, necessary to accomplish this goal.
Questions? Sir? If there are none, if we can please have a motion.
I move to approve agenda item 11X submitted by Development Company and it would be for a 12-month extension from February 5th, 2022.
Second.
We have a motion, we have a second. Any additional discussion? Hearing none. All in favor, please say aye.
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 Any denial or extension? Matter carries. 12 months is granted. Good luck. Hopefully you can get it done soon.
Chair, thank you. Members, thank you.
That moves us to Y Miller Farms LLC, C189, RC189. That's in Winnemucca.
Agenda item Y is for Miller Farms LLC, C189 and RC189. Miller Farms LLC requests an extension of the February 5th, 2022 deadline within the Winnemucca jurisdiction. Miller Farms is requesting an extension to become operational for the medical and adult use cultivation licenses until December 31st, 2022. Miller Farms reports delays due to COVID pandemic, which have limited the ability to move forward in perfecting its licenses. Additionally, Miller Farms has been working with the local jurisdiction and has contacted the CCB about determination of whether a local business determined the preschool or daycare in determining distance separation compliance. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Rendell and Michelle Miller are present via Zoom to give a brief presentation and address any questions you may have.
Thank you.
Hi, I'm Michelle Miller. This is my husband, Randall Miller. We are here in Humboldt County. In the end of 2019, we were successful in changing a moratorium against cannabis establishments here. We found a location, secured a lease, a contractor, and started to secure supplies. We obtained our special use permit for this location. During the process of obtaining the special use permit, the city manager brought an issue to light that she was concerned whether or not there was a preschool or a daycare. That determination was made by the city that it is a daycare on December 11th, and a letter and formal determination was received last week. We've submitted for an address change to the CCB for this location. We're requesting an extension so that we may become operational by the end of 2022.
Questions or comments by members of the board? With that, can we have a motion?
I move to approve agenda item 11Y submitted by Miller Farms LLC. If approved, the extension would be granted until February 5th, 2023.
Second?
Second.
Moved and seconded. Any further discussion? Hearing none, all in favor of the request for 12-month extension for Farms LLC, please say aye.
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 Nays? Any nays? Any abstentions? Matter carries. Good luck, and I'm glad you got your local zoning issues.
Thank you. Have a good day.
Thank you.
Thank you.
Chairman, I have a disclosure on the next item. I have served as an expert witness to a law firm that represented a party in litigation that involves Strive Wellness of Nevada. I have not represented either of the parties. But out of an abundance of caution, I'll recuse myself from agenda item 11Z.
Thank you. As to item Z, if we can have our report, please.
Agenda item Z is for Strive Wellness of Nevada, LLC, C206 and P131. Strive Wellness of Nevada was issued provisional medical production and cultivation licenses P131 and C206 on April 11th, 2018, within the Nye County jurisdiction. Strive reports once funding was secured, construction began in September 2021. Delays Strive still face include putting in the water line to the property due to permitting delays, which delays the receipt of approval from the health department, as well as supply chain issues still affecting the project. Strive has reached nearly a 70% completion level on the facility, anticipates the project to be finished in September 2022, but it requests an extension to February 28th, 2023, due to anticipated additional delays due to the global pandemic ramping up again. Staff have identified areas of concerns with this request. Specifically, two of the three owners, Donald Burton and Lawrence Lemons of Strive, also on the Harvest Foundation, the licensee similarly suspended by the CCD on November 18th, 2021, and the subject of a pending complaint for disciplinary action. The three owners on record for Strive are Donald E. Burton, 35%, Lawrence K. Lemons, 35%, and Sarah Gullickson, 30%. Mr. Burton and Mr. Lemons also collectively own 69% of the Harvest Foundation, LLC. At the November 18th, 2021 emergency board meeting, the board issued an emergency order of summary suspension for the Harvest Foundation, LLC, license C086 and RC086. The CCB also has a pending complaint on the Harvest Foundation, LLC's medical and adult use cultivation licenses. I'm available for any questions, and my understanding is that Chris Wolven and Nick Bolden and their counsel are present. Donald Burton, Lawrence Lemons, and Sarah Gullickson are present via Zoom.
Thank you.
Good morning, Chairman and members of the board. My name is Chris Wolven.
Nick Bowden. I'm the VP of construction for Item 9 Labs that is representing for Strive Wellness.
Chris Wolven, Principal Officer, Item 9 Labs, operating construction partner with Strive Wellness of Nevada regarding license number P131 and C206. Today, we're here to request an extension. With this project up and running since 2019, we have faced substantial issues and challenges. I think first, we had a real estate location which was unsuitable. We did have some issues with financing. We switched the GC company for the project. We have surpassed the milestone projects for utilities, and in terms of construction.
Yeah, so we have brought in the water line. We're waiting for the actual city connection. With the project shutting down, we had to resubmit for permits with Great Water. So that's come in, but we've also brought in the power to the site. So the whole subdivision we're in, we've actually brought water and power for them. So we're moving along there. Project is set to be probably temporary CFO by end of February. It's looking good, but we're looking for time to basically finish out the actual fit and finish of the product so that we can actually get it up and operational.
Questions, comments by the board members? This is an item for Chair Douglas, for the record. This is an item because you're requesting a 12 extension to try to at least put yourself in position for licensing. There is issues on the board as to your ability to effectively operate the facility because of problems with the Harvest Foundation license. It could impact us. Please understand if we approve you for the 12-month extension stay, that does not necessarily mean this facility will be licensed due to those concerns. This board has not addressed that issue yet. It's being reviewed and worked. So here not any speculations as to what's going to occur, but I just for the record so you understand that a 12 extension guarantee the other happening. So having said, we have a motion. Any other comments or discussion? Hearing none, do we have a motion?
Reference to item 11, Z, for consideration for approval to extend from February 5th, 2022, a final inspection for Steve Wellness of Nevada. I motion to approve.
Do we have a second?
This is Member Young. I'll second that.
We have a second. All in favor, please say aye.
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 Any dissents? One abstention?
Correct.
With that, the matter carries.
Thank you very much.
Thank you, Board.
That would move us to item 13. Proposed next meeting date for the board is February 22nd, 2022.
Chair, I believe you skipped the all-important briefing to the board from the executive director, which was agenda item number 12.
I skipped that. I thought we just had a report on all the counties in the state. I will be quick. I'm playing bulletin board today. Just three things. The office is moved officially from the Grant Sawyer Building to 500 East Warm Springs Avenue in Las Vegas. Staff is over there now. However, we will be continuing to hold board meetings at the Grant Sawyer Building while we build out the boardroom at the new office. The demographic survey this year is out. Friday is the last day for all registered agents to submit their responses. This is a requirement, so any help from those in the industry, point of contacts, licensee owners to help with that would be appreciated. And then finally, with consumption lounges, we are currently finalizing the next draft of lounge regulations. We will look to release those in the next week or two. And then planning for the next workshop on lounges to be sometime in February, ideally prior to the next board meeting. So with that, Chair, I'll answer any questions and then turn it back over to you. Questions by board members? Just for the record, I just note we are, as our executive director stated, looking at rules and regulations for the consumption lounges. And for those who are curious as to what's going on, we are trying to discern the regulations or the requirements, put it that way, that were set forth in the legislative issues. Give it, take it away all at the same time. It is a very, very much a Pandora's box that we're trying to navigate through and getting the next draft before you for comments as to what you think of them, but we are guided by the requirements of the state of Nevada, not our wishes in some cases. With that, we are open to public comment at this.
We'll start again in Carson City. Is there anyone wishing to provide public comment in Carson City?
There does not appear to be anybody here for public comment.
Okay, great. So then we will move down to Las Vegas. Is there anyone here wishing to provide public comment in Las Vegas?
Yes,
Hello.
sir.
How you doing? My name is Antoine Robinson. I'm here representing MedMen LLC, and gotta excuse me because hunger and nervousness is not a good combination. So now I'm here with the suggestion because I'm not sure at what capacity I'm allowed to offer suggestions for regulations, but Um, I work with the public. I'm a bartender at the D, and every day I'm um, I meet individuals who don't smoke marijuana, who are turned off by the smell of it, who perceives the public use of it as lawlessness. Okay, so as a longtime resident of Las Vegas, one thing I do know is that our tourist industry has never been perceived as lawless. Um, we have very good uh, law enforcement, and so it's time to make this more enforceable. All right, so my suggestion, it comes from a place of respect for you guys' knowledge, uh, existing entities, and uh, and of course the tourist public. Okay, so in the corridors of let's say the Strip, Fremont Street East, and the Art District, you need consumption spaces. I don't really like to say lounges because I think of somebody just, laying in a lawn chair, just, leaning back and smoking. So I like to say space. All right. So for an example, I'm gonna try to make this quick, but I was driving down the Strip, and we were stuck in traffic. And there's an area I want to say it's near the Venetian. And walking down the street, excuse me, there's a very kind of a narrow walkway at some point. Okay, so I observed an individual sitting in that walkway, smoking what I assumed was because of the smell and everything, 'cause I was right there, was marijuana, right? And I noticed people as they walked by, some people grimaced at the idea that somebody was there just out smoking marijuana in public. All right, so at that moment, I had an idea. I said, well, you need these spaces strategically placed along this strip and the downtown corridor and also the art district. Okay, so with that being said, these spaces would be in compliance, of course. These spaces would be of reasonable size. They would have reasonable ventilation to prevent odor. There would be no like overt advertising, for children that may be walking by these spaces, like a storefront, for instance, right? Okay, so downtown, for example, um, there's a strip of bars, okay? And a perfect example of a bar that would be ready for a space such as this would be, let's say, therapy, because they have a lot of room, and they also have space for another room that can be enclosed, that could be, ventilated, odor reduction. And I know it can be done because people did it for years, growing marijuana next to their neighbors. So we know it can be done, right? We know it can be done. So um, now I'm just I have a proposal. I have my summary, but I'm trying to make this quick. So imagine like let's say like a franchise. So in the area where I work downtown, there's two um, main cannabis retails, and that would be New Woo and MedMen. So imagine, let's say you had, let's say therapy, and they had a smoking space, right? Which they do. They have a hookah space. So that would be MedMen's and New Woo's jurisdiction, so to speak. So if a person was to open or be a, first of all, the bar is only offering the space like a lease, right? Separate management and separate procedures, right? So that jurisdiction would be MedMen's and New Woods. So that space would offer their products. So Therefore, the existing entities, hey, here comes a new entity that's going to meet the public first and take their business. So I feel like this is something that remedies that. Okay, so if you were to offer 4 licenses for, let's say, the property across the street, I forget the name, but they have a rooftop. It'd be perfect if they, if they, it would make a perfect place for consumption of marijuana, right? So same there. They would offer New Woo and they would offer MedMen. If a new retail came into the area, uh, it would be a prescribed distance. That would also be their jurisdiction. So they would also have to, those spaces would offer their products also. And of course, the product is single use. There will be time limits. There'll be, in some cases, I think, what do you call, reservations will be warranted, and to avoid lines and loitering. Um, I, right now, these just suggestions, and I can leave paperwork, and if you need to, if there's like questions, anything, or if there's like some legal issues with suggestions, I mean, I would like to hear it.
Sir, just so you know, this is public comment right now, so the board can't engage in deliberation or action.
Oh yeah.
If you want to leave your information with staff, then.
Yeah,
under
I see.
advice.
Yeah, because if I could be here all day if I kind of.
Of course. We appreciate your comments.
But and one more suggestion. So the spaces on the strip would be small and strategically placed, so that it will literally be um, an experience where you go inside, you choose, you consume, and you leave. And that's and I know it sounds audacious, but right now it's like better than no idea. You know what I mean? It's better to start trying to enforce this than to not do it at all. And I know that there's people out there who are being affected by marijuana smoke, and they're not users. And the main people who are being affected are the people who gamble the most. The ones who use the most, they're not really the gamblers, but it's the gamblers complaining. So we don't want to lose that. And part of my business, the gamblers are a big part of it. So I definitely respect, even as a user, I respect, what their concerns. So thank you.
Thank you, sir.
Hello, good morning. Um, we're from Illinois. We originally started our cannabis business here in Las Vegas several years ago, which was IGTM Las Vegas.
Could you state your name for the record?
I'm sorry. Berwin Tompkins and Victoria Williams.
I'm Victoria Williams from ACC of Illinois and ACC Transportation.
So we initially started here, our first teaching the classes of cannabis here in Las Vegas. We then went back to Illinois and were awarded several licenses in Illinois, one of which was for a responsible vendor to teach people about cannabis, get into the business. Some of the things you're proposing in your actual legislation for the consumption lounges. So we're back here to hopefully procure a consumption lounge, but also get into the education aspect of cannabis, as we already have accumulated license in Illinois to teach various things and get into the cannabis industry.
Like my partner said, we have looked over some of your regulations as you speak in regards to the consumption lounges. And we have already been approved in other states to do this actual training as far as regulations and compliance, and also sexual harassment prevention training in the workplace that we have already designed and was been able to teach that to people in the cannabis fields and the dispensaries and cultivation, craft growers, and also cannabis transportation. I was awarded the first cannabis transportation license in the state of Illinois. Before being awarded the cannabis transportation license, I was the first person approved to do cannabis education approved by the Illinois Department of Financial and Professional Regulations. Um, and that we also wrote Illinois First Dispensary Training Manual, which outlines a lot of the similar things that Nevada also is seeking as it relates to the laws and rules associated with cannabis. And so because we started here in Las Vegas, we're hoping to come back to Las Vegas and also continue to educate on responsible use of cannabis in those consumption spaces.
And one of the biggest things that we've been involved with is social equity. We know it's been confusion as far as diversity and social equity in cannabis. One of the things that we did in Illinois was able to go to the street level and get people that would not normally be in cannabis into cannabis on an actual 51% or more of their particular license. So through disseminating information, going into the neighborhoods, connecting with the people, properly getting information out, we've been quite successful in Illinois. We hope to bring the true social equity and opportunities to Nevada for people, for everybody, as well as produce money and opportunities for others. Thank you all.
Thank you guys for your time.
Happy New Year, Board, since I haven't seen any of you. And congratulations, Executive Director, on your new office. I'm Aisha Goins with Black Joy Consulting, and I know that we have held item 10, but I just wanted to give words on item 10 since I was here. I want to just thank the board for being conscious of the difference between diversity and social equity, the importance of what that is to the community. When we talk about diversity, it is important, and I do want inclusion in the marketplace, but I also don't want to water down the trauma and the generations of trauma that has been done to those persons that was most harmed by the war on drugs. And so I know that you are still deliberating on what all of it encompassing in putting together the consumption lounge regulations. And I absolutely don't wish that I was in your seats having to do that, because the whole world is waiting to see what you all are going to do. I do want to stand here on behalf of CEIC, Cannabis Equity and Inclusion Community, and remind you that those persons that were most harmed by the war on drugs are people. The ACLU just did another study in 2020 that says that 3 times Black and Latinx people are still 3 times more likely to be convicted of possessions in those states that are not regulated. Still, people are in jail because of cannabis. We are still dealing with traumas of those persons who have family members and people in prison for cannabis. And yet there are still people that we have seen line up here making money off of this industry. That is a specific person. They have been identified. I want this marketplace to be inclusive. I am going to always work. I'm going to represent the community. The community is my heart. I live to serve. It's my pleasure to serve them. And I want to just ensure that the board is considering that person, that you see them and that you hear them. And that when you're deliberating on what this should look like, that you remember that those are people. I thank you for your time, and I'll leave my comments with the staff. Thank you.
Thank you.
Any other public comment in Las Vegas? All right, back to you, Chair.
Public comment, that puts us into adjournment. We are adjourned. Thank you very much today for your time and consideration.